So thank you so much for waiting. We'll go ahead and get started. I know last we were here, there was some possibility of resolution. And we indicated that if not, then I wanted Ms. Brown to kind of give me a lay of what I was missing from those other matters so that we can get an order that's comprehensive and resolving those outstanding issues. One of the things that I tried to put on the record to make sure it was clear was that it was my intent that to give Ms. Horn what she was requesting, but I was trying to also be mindful of making sure that we didn't have to come back as often as we had come back previously. Once the court made its first ruling, we had a couple of contempts thereafter, and so I was trying to be proactive, but I think I was too proactive, as Ms. Brown points out, to the extent she believed that I had changed the final decree, and of course I can't do that. So I was trying to get an idea of where we can find a good medium where I'm giving you what you want and not, of course, changing the final decree. So did we come to a resolution?
We did not, Your Honor. I was hopeful and optimistic. I'm trying to balance right now. I really feel like the court ought to know the recent disclosure of access to funds, and yet I don't want to run afoul of disclosing an offer in compromise out of turn. But regardless, there was a substantial offer for Mr. Horn to suddenly access a significant amount of money, and I think the best.
I don't want you to. I don't think it. I do. Let me just stop you. I don't think it's fair for you to talk about any offers and compromises, because my position was, I think I've already indicated that I would give you the lump sum if you asked for it. I was trying. I'd already indicated I would do that, but I think I had already done that before, and the money did not come through. And your position did not come through, and to the extent we had like 3 other contempts still after that. So it was my position that perhaps we should lower those amounts so that we wouldn't have the continuous contempts, because every contempt requires more attorney's fees. So I was trying to be mindful of that. But you brought to my attention, which I think you are correct, that I can't change the nature of the decree. And so I don't. It is not as if what I put in my tentative order cannot be changed, because I don't mind doing it that way. I was just trying to be mindful and creative so that you wouldn't find yourself back here every month. That's what I was trying to prevent.
I appreciate that. And to answer your question, and again, I wasn't trying to go into offers and compromise. I understand that's not something we do here. To answer your question, we would ask the court to order Mr. Horn to come up with the entire lump sum now. The way in the proposed order that I submitted shortly before the hearing, which I just assume mark and tender into evidence at this hearing, and call it plaintiffs 2. I have plaintiffs 1 that's just simply an update of the liens.
Okay, hold on for a second. You submitted something when?
On Tuesday, you asked me to prepare a proposed order if we weren't able to resolve the case.
Did you send that in?
Yes, but only an hour before the hearing. I didn't finish it. It took me several hours actually to pull together all of the court appearances and what I believe from my notes and the exhibits that were admitted to be findings of fact that the court could make based on the evidence. So yes, I did. I believe Ms. Marshall might have acknowledged receiving it shortly before you got on the bench today. I sent it to Ms. Marshall and Ms. Harris and copied Ms. Winkleman. Ms. Winkleman has not seen the order before I sent it to the court because I only just finished it an hour ago.
Okay. So Ms. Harris, if you would check to see if you have it printed off, bring it to me. And Ms. Winkleman, you will have an opportunity to review it as well before I do anything with it anyway. And when you send proposed orders to me, we always double check them anyway. So I'm not going to sign it simply because it was submitted. I'll sign it if the court agrees with it. But I will give you an opportunity to review it as well before I do anything with it.
I'm printing it now, Judge, and I'll be right over.
Okay. Go ahead, Ms. Brown.
There were a few blanks. I was trying in the time that I had between Tuesday and today, and I wasn't able to start on it until yesterday for various reasons, but I was trying to put insights to the record. There were a few blanks there that I didn't make, which I can go back and fill in, or the court may reject the finding entirely. But I do owe a few of those there. But in summary, we are asking you to order Mr. Horn to pay everything in stanter, as I've updated the liens in P1, and I can share that on the screen as well. Ms. Winkleman has seen that. I sent it to her yesterday. I think I added one document for the state tax execution, which just supports the chart. But we would ask that all of those amounts be paid immediately, since we're now a year and a few days past the January 2nd, 2023 deadline. So that is our request in the proposed order. I had proposed a immediate incarceration with a purge amount and a purge date of January 31st of this year to get it all paid as a purge amount. And again, it's based on my conversations with Ms. Winkleman this week, and I'll leave it at that. I know I sent the court a few cases to consider. I would ask that I have an opportunity to just put those on the record as my concern with any order that the court might issue, and that we don't modify prior orders in this contempt proceeding. And if I may, I'd like to just put 4 cases into the record. The first one is Darroch, Darroch versus Willis at 286 Georgia.
I'm sorry, but I forgot to do this, and I want to make sure you have a court reporter, Ms. Cox. Are you all participating in the takedown?
Yes.
Okay. Sorry, I forgot to do that for the record. Okay, so everybody will have access to the transcript. All right, Ms. Brown, you may continue.
Yes, thank you. So the 4 cases I'd like to put into the court's record for today, Darroch versus Willis, Darroch versus Willis, Willis, 286 Georgia, 566. That's a 2010 case. Secondly, Jones versus Jones, 298 Georgia, 762. It's a 2016 case. Greenwood versus Greenwood, 289 Georgia, 163. That's a 2011 case. And then Killingsworth versus Killingsworth, 286 Georgia, 234, 2009 case. And all of those essentially stand for the proposition that the court, in issuing this order, cannot modify prior orders in this contempt proceeding. I think they basically say you can craft a remedy for the contempt, but not going so far as to modify the prior. And I know the court's acknowledged that. And I appreciate you setting this down so that we could discuss that today, but I just wanted to put in the record that those are the cases that I use as a basis for that. I would like to tender P1, which I can call up on the screen, which is just an update of the
Ms. Marshall, can you give Ms. Brown the ability to share?
So P1, the first page is just a chart of, and these are my handwritten things here, but there is no dispute, assuming that the bus stop financial is a current amount and accounts for the payment that we understand should have been made last month. That $5,403.69 should be the current amount. IRS for 2015 should be $2,816.18. Although interest and penalties are accruing daily, so that number is subject to change. I believe already that was a couple of days ago. Georgia Department of Revenue for 2015, $8,288.79. Arch Midland is the second mortgage. The current payoff, at least as of January 5th, was $55,357.91. The tax refund reimbursement due to my client currently that's not been paid is $266.41, includes $114 that we previously discussed. But again, these amounts, every time we have a hearing, they're subject to change a little bit. So that's why I wanted to provide the current first mortgage escrow shortfall based on the increase in escrow and overall taxes and insurance increasing, which again is changing daily. This $4,681.02 is what I understand to be the overall payoff balance differential from the increased mortgage. And as the court knows, the house was to be made saleable, so that would affect the ability to make it saleable. The outstanding medical bill, since we were here the last time, Ms. Horn had a notice that the amount that she had understood was all that was owed is different. Now she has accepted that she can go back and try to push back on the provider with that, because we gave a different number at the last hearing based on what we knew at that time.
I thought that it was like $300.
It was. And so I have actually not included that in my proposed order, but I wanted the court to see that these are amounts that Ms. Horn sort of gets taxed with addressing. So I have not included that increase in my proposed order because when we were last here, it was like $291.
Yes.
The Franz, Sanders, and Graton is still showing as an outstanding lien. Defendant contends it's expired, but we don't have any proof that it's not going to come into play when there's a sale or refinance. So we're asking him to provide proof of that, $1,241.07. And the LVNV is the same situation. They say it's expired, but it's still showing up in our lien search, $663.63. Again, taxes and interest and penalties accruing daily. What I have provided behind it is simply the IRS amount for 2015. This is a summary of all the years owed, but 2015 is the one that applies to this case as a joint return. The subsequent years are returns that we understand are individual returns that Mr. Horn would have filed. So even though the total amount shows $28,000, the amount that's at issue is the 2015, that amount being reflected here as $2,816.18. Those tax liens, have always been, we contend, a priority because of the refund seizures that are happening to Ms. Horn unexpectedly. As we go down, this is just another backup document here. The notes here, frankly, I'll just disclose are from Craig Horn, who is attempting to explain the status of these things because, as the court knows, he's been the one researching all of this all along. And this is the current state tax execution number. Again, we understand for 2015 of $8,288.79, which is shown in that chart. Again, it shows that, and this is in part because of, the court might recall in July, you allowed disbursement of some of the $20,000 that was put into the registry.
Right.
You allowed disbursement and I was to disperse some of that from escrow. And so those did go towards paying off those other tax years. What remains is, and you can see it here, is 2015, the $8,288.7.
Okay, go back to P1. Where's that on P1?
It's right here,
Right
Georgia
here.
Department of Revenue, the third line.
Okay.
So that, and then the last page here is a current payoff. And I say current, it was January 5. So it might change a little bit, but it was the second mortgage, $55,357.91. So this syncs up with the current order that I submitted as P2. And let's see if I can, that is here. And I know the court will probably want to take some time, as it indicated, and review it and discard what you don't like about it and modify what you might want to modify. But this is, as best I can tell, tracks the evidence and my notes and the things that you have said along the way in the various appearances.
Okay.
The court did in May, when we appeared for a status conference, you did order within 48 hours a $20,000 amount to be paid by Mr. Horn into the court's registry. He did come up with that. So without going into other things, that leads us to believe that he does have access to get money when the court is imposing that upon him. And given that he's had now over a year to extra to make that January 2nd, 2023 deadline that that we believe he should be held in strict compliance for, he should be able to come up with the remainder of the money. And the total is in the order that I submitted today. So with that, I think the simplest thing for me to do is just to tender P1 and P2 as my proposed order is fitting with what you have asked, Your Honor, of me the other day, and what I believe the evidence in the court's prior comments have revealed, provided that I did back out the most recent medical bill, and I can scroll down quickly enough.
That medical bill is most recent because it has happened after the hearings, or was there some problem with the calculation of the bill that was originally sent to her?
That's a good question. I think if the court would allow my client to explain that, my understanding is that she thought it was one number in October, and then she got correspondence after that indicated it was not resolved. Ms. Horn, can you address the court's question in that regard, only in that regard?
Yes, I will only speak about the Wellstar bill and the Blue Cross Blue Shield are currently insured through Mr. Horn's girlfriend Suzanne's insurance. At the time of our hearing, the amount was $297. I had paid off $100. When I came to the DeKalb County Courthouse to pick up the money that was at the DeKalb County Courthouse, I contacted Blue Cross Blue Shield. I was under the impression that everything was taken care of. Prior to that, I reached out to Mr. Horn, and I have emails to prove that I asked him about splitting it, his 75%, my 25%, to which it was declined. I even asked him when this was before like I said, I thought it was all taken care of, but there was an amount, and he declined to pay for it. And the email even states, that you're willing to let this go to collections in Gavin's name. I did speak with Blue Cross Blue Shield. It's not my job to reach out to their insurance company. I reached out to them and asked them to resubmit the claim. I also reached out to Wellstar to find out what it was that they needed. Blue Cross Blue Shield did not include all the information, so it needed to be sent to Wellstar. They gave Wellstar 30 days to respond. I unfortunately tried to keep into that 30 days, but did not hear a response on either end. I do know, in speaking with Blue Cross Blue Shield and Wellstar in the past couple of days, that they did reach out to Wellstar on several attempts. They are willing to send Wellstar again whatever they need. On the Blue Cross Blue Shield end, there are 3 different claims: one for $717, one for $874, and of course the one for $297. That full amount of $4,601 has gone to collections right now. So Wellstar advised me to call collections and see what I can do. So I've spent, if you were to ask them to produce the notes of me calling Wellstar last year, and then I just called both of them the other day, I have done extensive work in trying to, for both parties' benefits, get this bill amount down to what I thought was the $297.01, because I paid $100 on it. So I'm still in the process of, I need to reach back out to Wellstar. The lady gave me the collections phone number so that I can but I have gone on the Wellstar, my son's chart. So I have all the Wellstar, I can provide all the Wellstar bills and all that, but Blue Cross Blue Shield and Wellstar basically aren't
Let me just
matching.
stop you now, because I think you're still dealing with it. I don't think it's right for the court to, I don't even think we can address it right now, because we don't know what the number is right now.
And I think that's what my attorney, Chris, said, was that I'm willing to deal with that independently. I just wanted to share. I guess you asked me to share.
I did. Okay. I just wanted to make sure it wasn't something otherwise. Okay.
Yes.
So, and I'm trying to jump to really what we're asking for in terms of this order. Some of your email from December 15th, I did incorporate those things, but I also added in some findings of fact, which I believe were supported by the evidence. And again, that the court has in a word, you can modify it as you choose. I'm trying to get to the payment amounts that we're asking to be paid, and I've put in some case law here to support that. I believe he has, he is required to exhaust all available resources, and I put in some findings of fact related to the evidence in that regard. But here would be the payoff by January 31st, which would be our proposed purge date. It can be, of course, the court can modify that. However, the way that I've worded it, consistent with the case law, is he's in contempt now and he must be incarcerated now. However, there's a purge date, and if he comes up with these funds, he would not. It would be simply a purge amount. So that includes this 2015 IRS tax debt, Georgia Department of Revenue, 2015, the Arch Midland second mortgage he was to pay by January 3rd, 2013, the believed bust up financial balance. And I put a note here explaining how we came to that amount. We could not get an updated letter. I believe Mr. Horn is the only one that can get that. And then the first mortgage escrow shortage. And then I did address that, until he's made good on these things, he should be paying any increase in the marital residence mortgage, because we're well past the time when the house should have been refinanced or sold, and that's impacting Ms. Horn in a negative manner. So I put in all these proposed deadlines as everything by January 31st, and whether the court will inquire of him of his ability to pay, or the court will look at the evidence of the past and the fact that he's come up with 20 grand within 48 hours when he was compelled to do so. We do not think that this is an unreasonable ask. And essentially, we've got pending motions for attorney's fees. We would ask for an opportunity to update ours, because we've now had a couple more court appearances and some work here getting to the finish line. So I want to make certain that I include everything for my client. So I've asked until February 16 to supplement my prior motion for attorney's fees that was filed on October 16th, to which the defendant responded on November 6th. And then I did put in something here related to the incarceration by the purge date. And then lastly, because I anticipate that there might be an appeal, I've asked that the order be made a temporary order pending any possible appeal. So I have put out all of those things in there. And again, I believe everything I've said in this order is supported by the evidence, whether they were admitted through testimony or exhibits in the record. And I can finish up with certain of those sites that I wasn't able to complete before the hearing today. So I would like to tender P1 and P2 at this time.
Okay.
For the purposes of this hearing.
Okay. Yes. I think, yes, I'll accept those. I think for the most part, though, although it's just updated evidence, since based on what I had already previously accepted. Ms. Wickelman, what is your position? I know you haven't had a chance to take a look at the final order. I understand that. I'm not specifically asking about that. I just want to know if you have any concerns based upon evidence that was previously presented to the court, not based on whatever testimony, whatever discussions y'all may have previously had. Had prior to this moment.
And excluding any discussions that we had about resolving this case, I have had an opportunity to briefly go through the order. I would point out that what Ms. Brown is asking for is a purge payment of $76,547.59. 4,700 and something, $4,681.02 of which is for the mortgage escrow shortage. The reason we're here today is because when your honor issued your tentative order and what you would like to see drafted on February 15th, Ms. Brown responded that she sees this as a modification of a prior order. And I've gone through your letter, the letter from the court multiple times. And even as the case law that Ms. Brown referenced earlier, the court doesn't have the ability to modify prior orders, but can craft a remedy. And that's how I see what the court issued on the 15th. I don't think at any point in this case, at least since I've been involved, that Mr. Horn has not acknowledged that he's in arrears and is making attempts to modify that. And from what I see when I look at the letter on the 15th of December is these are the amounts and these are the amounts he's in contempt and these are the ways that I want that to be remedied. I started practicing a week ago, would have been 20 years. And I've never in a contempt order ruling seen someone come back and say, well, I don't think you can do it that way. You're changing the original order. It has to all be done at once. And this is something as candidly I've never had to deal with before. Looking at what the court has done falls in line with every other contempt that I've had where a remedy has been crafted based on ability to pay and the circumstances of the case. So to turn around and threaten an appeal and ask for $76,000 at one time, I'm just stunned at this point. And I would submit to the court that it would be my argument that seeking to add an additional $4,000 plus for what is anticipated a mortgage shortfall would be is modifying the order of what Ms. Horn is obligated to pay once the child support and alimony obligations are terminated. I'd also point out to the court that in the proposed order in P2 and in Ms. Brown's proffer or discussion with the court earlier, she indicates that she wants the defendant to provide proof that the Franz Selders and Graton liens and the LVNV liens have expired. How other proof is there supposed to get other than Georgia law indicates when liens expire unless they are renewed? And the title history and title runs in this case show that they were not renewed. They have expired. Georgia law shows that they've expired. Ms. Brown points out other case law that she didn't reference in her proffer earlier, in her order asking the court to find that defendants failed to exhaust all available resources at his command and has failed to show that he has not made diligent and bona fide effort to comply with the decree. I think we can show, and I think the court shows that he has made, in your December 15th ruling, shows that he has made substantial progress. And then finally, again, we're basing Ms. Brown is basing, or Ms. Horn is basing what they think ability to pay is on partly case law supporting someone's wife. The current testimony in this case from Mr. Horn is that he does not have a wife, and so we're basing his ability to pay on something that's on someone who's not even his spouse. And there's not evidence to show that they are married, and I will submit to the court that they are not married. I think that the court's order, or the court's intention to issue an order on December 15th, shows that it is crafting a remedy to resolve the contempt in an expeditious manner that, based on my calculations, would have this case, have these things paid off, with the exception of part of the second mortgage, in a year. But substantial progress would be made based on what he has been paying and what he has told the court he would continue to pay. I don't think that an automatic $76,000 purge payment is reasonable or possible, and I don't think it is. I don't think what you have already said you were intending to do is contrary to law.
Well,
Final.
let me put this to you, Ms. Wickelman, so I can see what your response would be. So generally, the court can open up evidence when I think it's necessary. There are two things that have happened. One, Ms. Horn has indicated that she cannot hold on to the house, that she must sell it, which is a very different thing than before, because I thought there was some consideration that she might stay in the house, some consideration that she may not be able to, and that she was just kind of staying the course the best she could to see if she can get this money before she placed this house on the market. One seemed like a little bit of voluntariness. Now it looks like she's in a predicament where she has to put this house on the market. So I think it's a very different circumstance than what was kind of previously before the court, because I wasn't sure, was she really trying to get rid of the house, or was she in a predicament where she might hold on to it for a little bit longer so that we could give Mr. Horn an opportunity to pay it off? Because what I did not want Ms. Horn to do was go to the closing table and have to pay off that house on her own and have to cross her fingers that Mr. Horn was going to pay her back. That's what I absolutely did not want. So as long as she was able to keep the house, that meant that gave Mr. Horn a little bit more time to pull these numbers together. But it looks like now Ms. Horn's position is, I need to get rid of this house because I can no longer keep it, which means that Mr. Horn's time is basically shortened. The second thing that I want you to be mindful of, because I understand your position, is that, the court did craft these remedies, but the remedies were trying to stay in line with what I thought was some negotiations that you all had already made, which that he was paying these things off and everybody seemed to be kind of satisfied that, monthly he was paying them off. So I was trying to stay in line with what I thought was acceptable for both of you. Okay. So it wasn't like I was doing it simply because, I don't think Mr. Horn can do it, any other way. I thought this was kind of in line with what you all were doing, and you were probably doing it that way to keep from these contempts for piling up. So I tried to draft something that no one asked for. I did it because I was thinking it was in line. What I want to hear from you though now is, tell me, what is your understanding of what do you now understand Ms. Horn's position is? She needs this house sellable now because she's in a predicament where she has to get rid of it. We have mortgage shortfalls that are coming up and things of that nature that prevents her from being able to hold on to it. What's your position in that regard?
Your Honor, other than the testimony that was provided at our last actual hearing with witness testimony, hearing that there's an emergency and she can't hold on to the house is news to me. The first I have heard about it was in Ms. Brown's response to the email with the letter. So I don't know what the circumstances are. So candidly, I can't speak to that. My understanding was that she was attempting, it was her intention to hold on to it. And so we were working through getting all of this paid off. So I don't know. I don't know what has changed. With regard to your
consideration of the court's position that I do not want Ms. Horn to go to the table having to pay off that $56,000 or any other debts that Mr. Horn has. And to the extent she's indicating that she has to go to the table now because of her own financial circumstances, which of course you can't blame her for because the house was supposed to be made saleable last year. So my question to you is, do you have some concerns about your client's ability to pay it off to the extent that you believe that it's unfair for her to make such a request?
Your Honor, at the risk, without disclosing settlement negotiations, because I don't think that needs to be on the record. We have made
in other words, what I'm asking you is, there something else you want to propose to the court?
If I can speak to my client, I will. I want to confirm that if there is something that I can propose, I need his authorization to do so.
Okay, so what I want to do is I'm going to give you an opportunity to talk with him. And when we come back, I'm going to open the evidence back up so I can hear from Ms. Horn about her need to sell this house now. And then if you want to produce any additional information about his ability to pay, I'll take it up at that point. That'll be up to you.
Okay.
Ms. Marshall, put Ms. Horn, put Mr. Horn and Ms. Winkleman in a breakout room, Ms. Brown and Ms. Horn in a breakout room.
Yes, Your Honor.
All right, you may proceed.
All right, Ms. Horn, would you please tell the court what your current position is about staying or selling in the house? And with regard to, I'm going to ask you two questions. So answer that one first, if you would.
My position as far as selling the house is that due to the order that was issued not being followed through with, and my ability to make payments, there's no ability to make payments on the house anymore. That's where I stand, because I have been trying to make it work. But at this point, my position is that I need to be in a position to sell the house. Or I am in a position and have no choice.
Okay, you heard Ms.
In your financial position, you cannot sustain the house. Is that what you're saying?
Due to the amount of time that has passed and my ability to tap into resources and what have you, they're not available anymore. And it's a major hardship on me.
Okay.
Specifically, has the fact that your state and federal tax refunds being reassigned by the IRS as a result of Mr. Horn's not paying the debt impacted your ability to pay the mortgage?
Yes. And other things.
Okay. And is it made it difficult or impossible for you to pay the mortgage?
Yes. The length of time that this has been going on and the unpayment and interest that is accrued on different matters, that would just increase the burden on me, has caused this situation to arise.
And has the required escrow deposit on the monthly mortgage increased during the pendency of this case?
It has, yes.
Has the insurance increased on the house during the pendency of this case?
It has.
Have the taxes increased during the pendency of this case?
They have. I don't have a current bill in front of me, but yes, they have increased.
Okay. And are you asking are you letting the court know that you need to sell the house immediately?
Yes.
And when you say immediately, what time frame do you anticipate that being?
I mean, immediately means immediately for me. But if the court would see fit to give, I mean, immediately is immediately for me, because I'm literally in that situation right now.
Okay.
You heard
I'm trying to hang on as long as I can.
You heard Ms. Winkleman indicate that, well, actually, you heard the court talk about she thought that the parties were somewhat working together while Mr. Horn was making payments on things during this case, and you heard Ms. Winkleman's response to that. Have you been agreeing in any way to allow Mr. Horn to make extended payments on the amounts that were due on January 2nd, 2023?
No.
You have to give verbal responses. Okay, don't just shake your head.
Oh, sorry. No, I'm sorry. I said no. No, I've not given any extended time or agreed to anything like that.
And has it been your understanding that the time that has elapsed since you filed your contempt in October been anything other than what you understood to be the court needing time to make a ruling in this case?
Those are my hopes since February of last year, for the court to make a ruling on the case. But yes, and specifically to your answer, yes, from the October hearing.
And are you asking for an expedited ruling at this point?
Yes.
That's all I have, Your Honor.
Ms. Wickman, do you have any questions for Ms. Horn?
Ms. Horn, last time you gave testimony in court, you let the court know that your intention was to keep the house, correct?
I don't believe that I specifically said those exact words. I may have said at the time that I had family members that could help me. I never imagined that this would be going on as long as it has been going on, and that Mr. Horn would be allowed so much extra time to satisfy what the judge ordered him to do. So at the time, I don't believe I stated those exact words, but I said I had family that could possibly help me. And it has been, very difficult for me. And I don't want to stay in the house. I mean, I didn't at that time either, but I had to have some place for myself and my children to live. I can't hear Ms. Winkleman.
You're on mute.
Mr. Horn was paying the mortgage on the house through May, correct?
Yes, he was.
And the increase in the escrow amount has been a significant challenge, correct?
The increase in the escrow amount has been a challenge, and the increase in the mortgage amount has been a challenge.
And the mortgage amount has increased about $400 due to the escrow balance, correct? Or the change?
Yes, I believe so.
If Mr. Horn were able to pay the $400 difference, would that assist in your ability to remain in the house?
Objection calls for speculation.
Can you ask that question one more time, please?
If Mr. Horn were to pay the difference, the $400 difference, would that assist in your ability to stay in the house?
No, it would
Objection
not.
calls for speculation.
I'll allow her to answer.
No, it would not help at all at this point.
So you were unable to pay the mortgage that you would have taken over in June regardless?
No, that's not the case. However, it's a hardship for me. I can split the payments and piecemeal them to make them, but I have been waiting, like I said, for the order to be taken care of. And so if it had been, things would be different today.
Okay, that's all I had, Your Honor.
All right.
One follow-up, Your Honor.
Yes.
Ms. Horn, is it your understanding that the divorce decree and the settlement agreement required that the house, the marital house, would have to be either sold or refinanced before you had to take over the mortgage in June of 2023?
My understanding was that the judge ordered Mr. Horn to pay everything off in January. The house was to be listed for sale in February. She gave me till June to sell the house. If I did not sell the house, I would have the opportunity to refinance it or take over the mortgage. However, the first end of the order did not take place. The debt was not paid off, therefore the house was not listed, and I didn't have an opportunity to sell it. However, I've been forced to pay the mortgage, even though Mr. Horn has not upheld what he was ordered to do since June.
If you had been able to refinance the house as originally contemplated, might you have gotten a lower monthly payment?
Yes, if the liens and debts that were encumbering the house were not there, I may have been able to refinance.
Objection.
The objection is?
Speculation. She doesn't know what the mortgage would have been reduced to if she had refinanced.
It's pretty similar to the question that Ms. Winkleman asked about her ability to pay for the house in different circumstances.
I understand why you're saying that, Ms. Wickman, but along the same lines, I do want her to answer that because I want to get an idea of what that would have looked like for her to have decided to keep the property, and her likelihood of being able to sustain herself. So I'm going to allow her to answer.
So if I'm being completely honest with you, I would have had to tap in, even if I basically would need to sell the house. Probably then I would have had a better opportunity to get a better rate to refinance it. I would have had to have someone co-sign with me. The house would not have had all the debt attached to it, which I would be carrying forward, and I might have gotten a better interest rate. I might have had a better opportunity at getting a lower rate because would be a first-time home buyer myself. I've never personally purchased a home. It would have put me in a position, Your Honor, if everything had been taken care of, because I would have had options, and I wouldn't be, I have no options now, the way things have stayed consistently.
Okay.
Ms. Horn, are you asking the court to sign the order that we've tendered into evidence that the court has accepted as P2, our proposed order?
Yes.
That's all I have, Your Honor.
All right, thank you. Ms. Wickleman, do you want to put on any additional evidence?
I do not.
Okay. All right, then. So the court will take all of this in consideration, and I'll get back to you very shortly. I'm going to make this my focus, hopefully by today. But I know I will have it reviewed by today. I might have to go back and look at some of the videos if necessary. That might keep me a little bit longer, but I can assure you this is something that the court is going to get out quickly.
Your Honor, the one thing I would ask, Ms. Brown in her order has asked to supplement her request for attorney's fees. If she do so, I would like to file a response to that.
Okay.
I would not have an objection to Ms. Winkleman responding to my supplement.
All right. All right. I think I have everything I need. Thank you so much. Y'all take care.
Your Honor, may I, as the plaintiff and the movement, have one brief response to make a couple of points to what Ms. Winkleman said before Ms. Horn testified? Just a couple of points.
Say that one more time.
May I respond to what Ms. Winkleman argued as the moving party and the plaintiff? Just a couple of very brief points.
Okay.
First is she referenced a couple of cases in the proposed order that I submitted today. Those cases were argued in my closing argument at the February 9th hearing. They're not new cases for the court. Second, with regard to crafting a remedy for contempt versus modifying a contempt, one of the cases that I cited at the beginning of our hearing, Greenwood versus Greenwood at 289 Georgia 163, that court specifically held that extending a deadline that was previously set is an impermissible modification. That case is very much on point to my concerns with allowing Mr. Horn additional time. Lastly, to the extent that Ms. Winkleman argues that my request for a deadline of January 31st and a purge amount of over I think she said $75,000, it's not just 20 days that I'm asking you to allow him. He's had 3 years since the 2020 divorce and a year extra from the original payment deadline of January 2nd of 2023. Under no circumstances has my client acquiesced to extending payments during the pendency of the case. And the court indicated something that I want to make certain I clear up on the record. We understood, based on having our final hearing in February 9th, coming back in May for a status conference on May 24th, coming back in October 26th. Meanwhile, I had my original motion for contempt, a supplemental motion for contempt filed in April, a motion for contempt of the incarceration order filed in June. I could think of no better way than to express the urgency on behalf of my client to have this case resolved. I understood that the court was probably being very careful given the large sum of money that was at issue and trying to afford Mr. Horn time to work his way out of contempt. And I understood that all of this time has been the court needing that time to make a fair decision in the case, and is not an acquiescence on our part of extended payments. To the contrary, as the order that I proposed shows in the evidence, he didn't even start making any payments or any movement on all of these liens until June of 2023, 6 months after the original deadline. So I think your review of the evidence in my proposed order that cites to the evidence will refresh your recollection on all of that so that we can get a fair outcome in this case for Ms. Horn. So we, under no uncertain terms, have extended any deadlines, nor do we wish to now. And we are asking for the immediate incarceration and purge amount for those reasons. Thank you, Your Honor.
All right, thank you very much. I'll take that under. Oh, shucks. Are y'all still with me? Hello?
Yes, we are.
Okay, I'll take those under consideration. Thank you so much.
Thank you, Your Honor.